Well, good afternoon. Thank you very much for joining us. I'm Jonathan Chamberlain, a partner here in the Employment, Labour and Equalities team at Gowling, and I'm joined by my colleagues Siobhan Bishop.
Good afternoon, everyone.
And Richard Lee. Who perhaps hasn't unmuted his microphone yet, but that can only be a matter of time. It seems like only a few days since we were here, and that is because it is only a few days since we were here. This is a very fast-moving area. The government issued new guidance on Saturday night, and as recently as this morning, we're making important clarifications and statements about the scheme. However, different agencies of government are not quite singing off the same hymn sheet. It is, however, definitely worth updating you since our last webinar, so thank you very much for joining. What we're going to do is I'm going to briefly run through what we already know. I'm then going to summarize just who this scheme applies to. Siobhan is going to take you through the changes to employment issues. Richard will then pick up on the pension side, and they'll come back together for some of the really tricky issues which still remain, one of which is holiday. I expect that a number of you will have questions about holiday. Indeed, many of you will have questions about lots of this. Please do use the Q&A section of the Zoom. Now, I will take you through what we already know. This is a temporary scheme open to all UK employers. That is to say, everyone with a payroll, and we'll see the significance of that in a moment. It's going to run for at least 3 months, starting on the 1st of March 2020. I think if I was a betting person, then I would say that it's likely to carry on until June at the least, but we'll see. Employers can claim up to 80% of furloughed employees' usual wage costs. We'll come on to what usual wage costs are, plus the associated employer NICs and the minimum automatic enrolment employer contributions on that wage. There is a cap on the wage of £2,500. Now, here's a new point that came out this morning. Okay, a question that we've been asked is, when will we get our money as employers? And HMRC said this morning in evidence to the House of Commons Select Committee that the portal will be open on the 20th of April this year. They are testing it with some employers at the moment. You will be able to claim in advance of payroll, up to 14 days in advance of payroll, and the money should be with you some 4 to 6 days after you've made your claim. That's what they're saying. Let's see what happens. But that is new information as of this morning. We had the original guidance on the 26th of March. That was updated as of the 4th of April. So let's now move on to the next slide and look at who it is who is covered. Employees must have been enrolled for PAYE online by the 28th of February. Now, what's been emphasized in the recent guidance, the effect of the recent guidance, is this is a payroll scheme. We said last time that it's important to think of this in terms of a scheme between employer and the revenue. It's about what you can claim back, which is why there are so many difficult employment and pensions and questions left unanswered. This is about a money flow, not really about employment rights. We're dealing with the accidental consequences, if you like, of that. But payroll is crucial. That means apprentices are covered. They can be furloughed. They can continue to train. That's an important concession by the revenue. And employers, though, must make up their pay to the otherwise statutory minimum national living wage, national minimum wage, etc. There is a whole section of extra guidance on apprentices. So we're not going to go into any more detail on them today. The detail in relation to apprentices is much more set out than it is in relation to other employees and can be found on the government website. Some of you will be pleased to know that you can furlough your nanny. Perhaps more significantly, you can furlough agency workers and the so-called Limb B workers, that is the people who identify as self-employed, if I can put it that way, but provide services exclusively to you. What we're seeing with some employers is they're saying, actually, now we've looked at these employment classifications, these are probably employees. I wouldn't bother with sorting out their employment status right now, park that one until later. You can furlough them if they're on your PAYE payroll. So that's where we're at the moment. I'm now going to hand over to Siobhan to pick up some of the key issues which have changed.
Thank you, Jonathan. And there's plenty of changes in the new updated guidance. There are two sets, which is an employer's version and an employee's version. So there are some slight differences between those, but I'll pick them all up in the round. And in terms of the main changes, I'll run through those at some speed, but I first want to identify three particular areas where we are interested in the practicalities of it and the ones that employers have been particularly interested to hear. So if we move on to that, the first is rehiring employees. So this is interesting because employees who are left their employment on or after the 28th of February, whether for redundancy or any other reason, including resignation, can now be rehired by the original employer, because of course they wouldn't be eligible to be furloughed by their new employer if they've started a new position. And that is covered in both the employer's guidance and the employee's guidance. So it encourages perhaps people to ask for this as well. And I certainly have seen a number of social media tweets and so on, encouraging employers to accept people and encouraging employees to ask for that to be done. Of course, the point to note is that employers are still not required to re-employ their former employees or place them on furlough. And the guidance isn't quite clear on how this re-employment might work. So are they on a new contract starting at the point that they are re-employed, or does somehow the original termination disappear and they're taken as having been employed for the whole of that period? So the new guidance suggests, and it's probably right, that they can be re-employed, so that continuity of employment, so that's their period that they have been employed, which attracts certain employment rights to it, would be broken, and they would have new terms and conditions. Now, if this is something you are considering doing, also note that from now, from the 6th of April, there is the new Section 1 Statement of Employment Particulars, which you need to comply with, and that's a day one requirement. But if you don't have time, because there's quite a lot of extra practicalities that need to be added in, and a lot of information that needs to be added into that compared to the old statement that was required, you should just do that as soon as possible. The other thing is that it's important that the employer remembers there are employment law implications of rehiring someone. So particularly if they've been made redundant, what's going to happen to any redundancy payment that's been made, any notice monies that have been paid? Are these going to be repaid? Perhaps they're even promised under a settlement agreement. Settlement agreements aren't always used for employees that have caused a problem. They can be used in other circumstances as well. And of course, employers may well have sympathy for some employees who have genuinely left after many years of good service and who are on good terms with their former employer, and they really would like to help them out. Equally, there may be requests from employees that are less in favour, those employees perhaps who've resigned under a cloud or were in fact dismissed for another reason, even a disciplinary reason. And employers would need to be very careful about thinking whether they would re-employ those people. Also consider whether the effect on continuity of employment, because I said that's not 100% clear, and there's also some risks about employees having then accrued 2 years of service if they have not yet got it. Of course, there's the issue of getting the money back, which Jonathan's talked about, and there may be a delay on that, and who's going to pay for that. and also what the likelihood of this role continuing is. So there's some of the kind of issues. But you should be aware that if you refuse to rehire someone, there is a theoretical risk around that. Perhaps if they have been, could argue that they've been subjected to a detriment, for example, because they had a whistleblowing claim. And if there's any element of selecting employees to be re-employed, but not re-employing anyone who left since then, think carefully about the selection criteria and any discrimination angles in respect of that. Now, quickly moving on to rotating furlough, the good news is that this is much more clear now that this is possible, so employees can be rotated on chunks of furlough leave, provided that that is for a minimum of 3 weeks. And that's what we indicated last week in our seminar, in our webinar, and that's more confirmed now. And that will help address those employee issues, perhaps where there's relations between the employees are strained if some groups are at home, particularly if their wages are being made up to 100% doing nothing and others are bearing the brunt of it in the office or working at home. And of course that won't work for all employers, but it is an important thing that employers have been keen for clarity on. So think about that really carefully as to whether or not you may take advantage of that possibility. The one thing to be clear is, though, that those that are at home or those that are those on furlough must not do any work at all. The third area is shielding employees, and the updated guidance clarifies that employers can use the scheme for shielding employees, and those are the employees who are in the most vulnerable groups who have been advised to work from home for 12 weeks or stay at home for 12 weeks in accordance with the public health guidance. And it also covers those who need to stay at home with them. And shield with them, perhaps such as their carers, if they can't work from home and you would otherwise have made them redundant. Now, that's really interesting wording because nowhere else is there a requirement that the employee should meet this test of having otherwise been made redundant. So it's not clear if that is an oversight or an error that it's snuck in there relating to shielding employees, or whether that actually is a much higher test in relation to them. So we haven't got extra guidance on that. I'll just quickly run through the extra changes that have been made as well, and we'll pick up some of these later in the seminar. So it's anyone that's on PAYE, including the agency workers, and if you're employed by your own umbrella company, you can claim back through furlough. Also non-employees such as directors and LLP members as well. Foreign nationals are eligible to be furloughed, and if you're on SSP, as soon as that ends, you can go on furlough afterwards. Employees on fixed term contracts can be furloughed, and those contracts can be renewed or extended during the furlough period without breaking the terms of the furlough scheme. Claims can be backdated to the 1st of March, where employees have already been furloughed. And administrators can access the scheme. We highlighted this last week, but there's a new requirement, and that is if it's a reasonable likelihood of rehiring the workers. So that will be as a result of the administrator aiming for a sale of the business as a going concern. Now, there was a Treasury Select Committee virtual evidence session this morning, and there were some nuggets out of that. So the committee were asking and trying to push to understand why this scheme could not be extended to allow for short-time working because they are not eligible to be furloughed. And the very clear answer from HMRC was that was no. And the second point the committee wanted to raise was that those who had job offers with start dates post the 28th of February should be included. And again, the response was clearly no. 28th of February is a hard cut-off date, necessary policy decision to get the scheme in place quickly. But the Select Committee did say that they would be taking up these points with the ministers as policy decisions. So potentially there may be some movement on there before the scheme is up and running, and we'll be watching out for that. Final word of caution, which we did highlight last week, was that there is some wording in both of the guidances which talk about, maintaining your current workforce because your operation has been severely affected by COVID-19, and the purpose being to retain employees and protect the economy. And there's also possibilities of auditing and monitoring the businesses even after the scheme closed. So there is the risk that if there are any errors, that these will be retrospectively picked up by HMRC, subject of course to their resources that they have available to do that.
Okay, Richard, are you now in a position to take us through some of the pensions issues?
Sorry, should I just go on to my next
Sorry.
on
Yep,
the previous slide? Yeah. Okay, so that was so can furloughed employees work for another employer? Again, that's another question that we've seen and been asked a lot. So we already knew that they can take part in volunteer work, and it now, as long as you weren't providing services to or generate revenue for the organisation, that was allowed already. But the employees guidance now confirms that you can't do any volunteer work for a company or that's linked or associated with your employer. So what about somebody else, though, somebody not related to the employer? So it is possible, as set out in the new guidance, that you can, because it allows the organisation that has furloughed employees to actually assist in finding new work or volunteering opportunities whilst that employee is on furlough, as long as that's in line with public health guidance. And you could allow that, well, perhaps your business is closed, for example, and it would be a good opportunity to allow your workforce to fill areas where there are shortages, such as food or care. And the key, of course, is to look at your contract as well, because many contracts will exclude employees working for anybody else. So that might need to be waived in the meantime, or you might want to say that they can only do it with agreement, even if you're generally supportive of that approach. Now, some people might find this surprising because somebody who is on furlough could be being paid up to 100% of their salary under a furlough scheme, and also be earning the equal amount in another job at the same time, which is an unexpected windfall. But obviously the government have taken it as a priority to allow employees to fill some of these sectors where there is a labour shortage and to keep the country running, essentially. So that's another one that you need to think about. There is also indicated in the guidance a starter checklist, perhaps if you are the employer who's looking to recruit some of these employees who are on furlough. There is also one extra thing on if you are in a position of recruiting people to fill shortages that you have in your business, whether or not they're on furlough, and that there's a temporary adjustment to the right to work checks because of COVID-19, and that was announced by the Home Office on the 30th of March, and there's a sort of limited right to work check in place to enable social distancing to take place whilst carrying out that check, and that's a temporary one in place just for this period. Move on now to those employees who have caring responsibilities, and of course some parents and carers can work from home, even though it may prove challenging in some cases, but they can effectively combine work and care, but clearly some groups are just not able to do that. So the updated guidance confirms that employees who are unable to work because they have these caring responsibilities resulting from COVID-19, that can be furloughed, and that's irrespective, we think, of the position regarding the impact on the particular business. So that means that employees who need to look after children or other dependents can be furloughed instead of taking annual leave or parental leave or some other kind of unpaid leave. And we know that there have been reports of employees, especially women, but also single parents, parents of very young children, and parents of children with special needs or disabilities who may be particularly affected by this and really welcome the opportunity to be furloughed. But there is still no right for an employee to be furloughed. They can ask, but the employer does not have to furlough any employee on their workforce. It's still an option for the employer to consider reducing their hours or pay, or look at other employment law options around them as well. But it is really important to consider individual circumstances of employees, particularly at this time, and comply with the general provisions under employment law, such as preserving trust and confidence and avoiding any risks that any of your decisions may impact on a potential disability claim as well. Very quickly on apprentices, the apprenticeship levy and student loans should continue to be paid as usual, and there is also updated guidance on that, talking about if there's a break in learning, and if that's greater than 4 weeks, the employer should notify the training provider about that. I won't go through all of those, but there is also separate guidance, which I do want to just flag, for apprentices, employers, training providers, endpoint assessment organisations and external quality assurance providers, and I would refer you to that as well for more details. Now, directors. So I mentioned that these are included in the group of non-employees who can be furloughed. So if you're a salaried director, and often directors are employed under service contract, but they're also an employee as well as a director. But the guidance does point out, of course, you have to comply with normal company law provisions. So the fact that they're going on furlough should be formally adopted as a decision of the company, noted in the company records, and communicated in writing to the directors concerned. There is a slight exception relating to directors on what work they can do. They must not generally do work, as all employees must not do work other than potentially training. But if they have statutory obligations that they owe to the company, they can do that as long as they do no more than will be reasonably judged as necessary for that purpose. So it's not entirely clear what reasonably necessary is, but it would probably be the minimum, the absolute minimum. And it's really important, particularly with directors and also other senior employees, to make it really clear that they are not to do other work, because if they are doing other work, the risk to the employers of the scheme will not reimburse them in respect of that. So even picking up the odd email, and directors may be more tempted to do that than some other employees. So we think the kind of things that the minimum requirement will be, including filing an annual return to Companies House, maintaining the company's statutory books or preparing statutory accounts. It's clear that talking to customers and suppliers or promoting the business in any way, even on social media, will be going over and above that. The public sector. Now, the scheme is available to public sector organisations, and the guidance only changed in a very small respect in respect of those. Of course, the government expects that the scheme will not be used by many public sector employees because they are generally continuing to provide essential public services or to contribute to the response to the coronavirus outbreak. And the minor changes now, they expect most employers, rather than the majority of them, will be providing essential services. So that means that they can't really be furloughed in any event. But it is still possible. For example, some bodies will receive both public and private funding for some of their functions, for example, in the care sector, and it would be quite difficult to separate out those people. The question is, where does the money come from? So it might be really hard in the care sector, but there are other public sector organisations which are funded by the public sector, where it might be easier to separate out those duties between some employees who are providing publicly funded roles and privately funded roles. So it is still possible. And of course, some publicly funded organisations will not have work to do, perhaps in the arts sector. There's also separate guidance on how payments to suppliers of contingent workers impacted by COVID-19 are to be made and dealt with, and I refer you to that as well. So that's my section done, and I think it's over to Richard now.
Yep, thank you very much, Siobhan. Good afternoon, everyone. We've got a real treat for you now, furlough, pensions and benefits. So this will be a fascinating next 10 minutes or so. Jonathan asked me to do 1 minute, but you know, I'm now on the mic, so I think 10 minutes would be quite useful for everyone. We also did a webinar last week on furlough pensions benefits. So I'm just going to summarise the main points coming out of that, and then just look at anything that is useful from the most recent guidance. In summary, the pensions and benefits aspects of the guidance are very, very brief indeed. So that's the headline. We're just having to read between the lines, and there are very few lines. So number one, you can see on your screens, the mismatch between the amount that employers will be able to claim under the JRS and the normal pension contributions that they make. Second, it's clear and has been stated that the duties under the Pensions Act, so automatic enrolment and all of its provisions, continue to apply during this period that has not been suspended. Third, we're having a lot of employers asking us about making changes to their schemes to deal with cash flow protection in particular. You've got to remember on the pension side that there's usually a minimum 60-day consultation for listed changes. That's including if you're going to close down an arrangement or if you are planning to reduce employer contribution rates. And we'll come back to both of those. And then finally, don't forget, if you are making changes on the pension side, that you need to check the employment contracts and handbooks as well, because separate consultation and agreement may well be required in addition to the pensions consultation. So those are the first issues. Just moving on to the next slide. So these are the 6 things that came out of the first webinar, just key points on pensions, what to look out for. So member status, in other words, whether you have active members, so employees who are paying into the scheme, or whether they become deferred, in other words, they're treated as having left the scheme. Furlough, as we've heard, involves continuation of employment, so it's not a change to the employment relationship. And so that would indicate usually that employees would remain within the pension scheme and pensionable service as active members. But it is very important to check the rules themselves, because there are rules that we've already seen which can make individuals automatically deferred. In other words, they would automatically be treated as having left the scheme under an absence rule, for example, or an eligibility rule. So very important to check, and in particular on the defined benefit side, or final salary, cash balance and career average, because it changes the calculation of the benefit. At the point at which someone moves from being active to deferred, that will affect the level of the calculation of the benefit, so important to check. Consultation during lockdown, pension side, yes we can, is I think what we need to say on that. And provided all relevant and affected members have got access to IT systems to allow exchange of information and consultation online, that is acceptable on the pension side. 2P, we're not going to go into detail, very complex area already for the interaction of occupation and personal pension schemes on 2P transfers. But what we would say is that if there are redundancies, in particular, if there are other dismissals, and it might be difficult to manage the movement of people from furlough to redundancy or re-employing, as Siobhan's mentioned, the crucial point, particularly where you have final salary benefits, is that you need to check again the status of individuals. Once someone is dismissed, they might be entitled to early retirement benefits or redundancy benefits under the scheme. Generally those are expensive, and they would need to be funded for in the short term. So be careful when there are 2P transfers involved, and in particular where furlough is concerned. Salary sacrifice, we've got some more points coming up on that. Just to confirm, we're looking at the base pay analysis for achieving the refund of costs. So it's gross pay after sacrifice. And I think one of the attendees has asked the question, so you only get the minimum automatic enrolment contributions. So 3% of qualifying earnings on salary sacrifice, okay? Finally, furlough trustees. So employees can be trustees, either company appointed or member nominated. And to the extent that they are put on furlough leave, our view is that it's permissible for furlough trustees to continue during the furlough period, because their duties as trustees are entirely separate and generally are unpaid, and so would not fall within the scheme. So that's the second lot of pensions issues. Just moving on to the next slide. So scheme rules. So each of your arrangements will have rules. You need to check where furlough leave fits in. Does it fit in the absence rule? Does it fit into the eligibility rule? Is there just a gap and it's not clear? But because of the point I mentioned at the start, it's important to understand exactly what furlough does to a member's category and status, active or deferred. Second bullet, extremely important as well, what is or how is pensionable pay defined? Some schemes it will just be basic pay or wages or total earnings. It will be total earnings, but excluding overtime and commission. So all schemes have different definitions. So you need to examine what the definition says, both in terms of calculation of benefits, but also how contributions work. So what will the contribution structure be if you've got people on furlough? Now, sometimes it will mean that you're paying contributions on the furlough leave, but not always. Again, it depends on the rules for the specific scheme. And finally, just picking up a point I mentioned again, employer, if they're seeking contractual changes alongside the pensions changes, and some of the pension provisions might be contractual, then you need to build in time for negotiation and agreement, as we've mentioned before. On a collective basis, the time periods are shorter than pensions, so we're looking at 30 days or 45 days. But you must make sure that you don't forget about the additional potential consultation and agreement provisions. And then finally, once you've got all that in place, you need to make sure that the administration of the new provisions is correct and accurate. So for those of you who have schemes with trustees, that will need to be given to them as soon as possible so they can set up the correct changes to the administration system. If you use contractual arrangements with the insurance providers and other pensions providers, again, you'll need to tell them what you're doing so they understand what will be coming into their arrangements. So just moving on to the next slide. Nearing the end of your pension session, but just carry on with the next one. So the pensions regulator, what have they said? Pretty straightforward. Benefits need to be paid as usual. We need to be very careful at the moment of scams. There are, I'm sure many of you are aware, billions of pounds worth of benefits exiting UK schemes into arrangements which are unlawful, and funds tend to disappear overseas. So there's obviously a lot of change at the moment, and the risks are fairly high of people falling foul of those scams. Employers need to keep contributing, and they need to be helping individuals decide whether to continue saving or not in these difficult circumstances. Many people's pay will be lower for a temporary period, which may mean that they would like to adjust the amount they are saving. And the regulator recognises that it's a difficult time for everyone. A huge scale of this means that they understand that there'll be technical breaches here and there. And I think they're basically indicating that they won't hold employers to the letter during this difficult time. So just moving on to the next slide. Tricky issues. So this is just the update. Siobhan and Jonathan have been mentioning on the employment side. Again, just to reiterate, very, very little detail on pensions. All we've really had are the 3 points here, just some clarification. So on salary sacrifice, HMRC have confirmed that COVID-19 would be classed as a life event, which would mean that existing arrangements could be varied to meet individuals' personal circumstances. Clearly, employers need to be careful not to advise their workforce on the tax consequences, and unravelling a salary sacrifice arrangement will have tax consequences which individuals need to be aware of and take care with. Regular payments, this was already in the guidance. So the employer can claim for any regular payments they're obliged to make. Again, so a bit like salary sacrifice, where there is a legal obligation to the employee, wages, past overtime, fees, compulsory commission, but excluding discretionary bonuses, tips, commission payments, and non-cash benefits. So that's important again on the pension side. Essentially, employers can only claim for that minimum 3% of qualifying earnings. So the monetary amount per month, and that is it. So the non-cash benefits are not included within their ability to reclaim. And then benefits in kind. So that, again, we're just emphasising that those cannot be included. So salary sacrifice pension contributions, which reduce pay. And that does mean that where there's an obligation for an employer to keep paying, that looks like an additional cost. So in terms of the pensions elements of the repayment scheme, although there is no guidance, and so employers who have defined benefit schemes and employers who are using money purchase or defined contribution, but on a different basis to qualifying earnings, so they have certified at one of the 3 tiers, those are all alternatives. And it looks to us as though the HMRC are basically saying all you're going to be able to retrieve are the minimum amounts, which are stated as being monthly, in relation to the qualifying earnings band. So although we would expect further guidance, at the moment that seems to be the position. So if you're an employer that pays higher contribution rates, or you pension total pay without limits, those additional enhancements are not going to be something that you can recover under this arrangement. And I think that's pretty much the end of the pensions piece.
Well, not perhaps quite, Richard, because you mentioned that you'd be coming back to consultation. So you might just want to add something in a moment, because Siobhan is going to pick up on what is still problematic, which are the consultation obligations with employees. Given the time available and given the contract, the issues around holiday, we've got lots of questions on holiday in the Q&A panel. If you could canter through this, indeed gallop through this consultation piece, Siobhan and Richard, and then give Siobhan a chance to do the holidays, and we can perhaps pick up at least some of the questions at the end.
Okay, so you have to discuss with your staff and agree any furlough with them. You have to keep a record of that for 5 years. Generally, of course, employees are consenting quickly, provided that the tone of communications and the right reassurance is given to them that they're still employed and their furlough is to protect their role or to keep them employed for a further period of time. The potential difficulty is when you get into this collective consultation, because the guidance does indicate that there is no exception for furlough in terms of whether or not you may need to collectively consult with your employee representatives or trade union if you have one. And what we're seeing is that if there is a recognition agreement in place, that can be done quickly. Generally, there's a lot of understanding and appreciation of the situation, and the trade union representatives there are being very pragmatic, and it can be done in a very short period of time. If there aren't any employee reps available who are suitable, who've been elected for this purpose, or you think they would qualify as being elected for this purpose, it becomes a little bit more tricky depending on what you're proposing. And I think that's the key, is to consider what you're proposing really. Is the alternative strategy that the employer will be definitely dismissing these employees, or is it that you haven't yet decided? Because of course many employees will agree, and it may be that you don't need to get to the stage where no proposals are actually being made to dismiss employees. However, if you are at the point where collective consultation is triggered, don't forget to submit the HR1 form, because that is a criminal offence if you fail to do that. I'll leave it there.
Thanks, Siobhan. Just coming in on the pensions very briefly, I mentioned it. So pensions consultation is less legally demanding than the employment side of things. Where there are listed changes proposed, so where an employer is either going to shut down an arrangement or reduce contributions or suspend contributions, which is the most relevant for the purposes of employers at the moment, there's usually a minimum 60-day consultation period. Clearly at the moment that looks to be a very long period, and you wouldn't be able to introduce the changes usually. The regulator has not issued any communication about suspending that or relaxing that, but it is possible to apply for a waiver. And in addition, even if you don't comply with these provisions, it does not invalidate the changes. What it does is give the regulator a right to levy a fine of up to £50,000. I have to say that in these circumstances, I think the risk of the regulator levying a fine would be pretty low. The other consideration for employers is possibly to go through a less formal and shorter process, still exchanging information, asking for views, but possibly cutting down the length of time to adjust it for introducing these changes more quickly. And it is also possible that if you are going to lower the contribution rates, say for 3 months, but then when this has passed and trading is good again, you can reinstate them and backdate them. That may mean that you would not need to go through the full 60-day consultation because there hasn't been an actual lasting change to the benefits. So that's all I'm going to say on pension consultation. Thank you.
Thanks, Richard. And Siobhan, can I leave you to pick up the issue of holidays, and in particular the fact that HMRC and ACAS appear to be saying different things?
Yes, this is a really tricky area because we are having conflicting advice. I wouldn't put it any higher than advice or suggestions being made, but the actual guidance, neither the employers or employee guidance covers this issue at all, even the updated version. But just going back to basic principles, and I think a lot of what I'm going to say now will address a number of questions I've seen coming through, so hopefully a lot of questions will be dealt with in the next section. So if you are an employee or worker who is on furlough because there's no work and you're under the COVID scheme, you can still request and take holiday in the usual way, including bank holidays. And employees and workers must get their usual pay in full. We'll come on to what usual pay might mean in a minute. So the bank holidays, obviously a very timely issue. We've got a number of bank holidays coming up pretty shortly. Usually these are part of the legal minimum of 5.6 weeks paid holiday, and employees would get their usual pay in full for bank holidays. And employers and workers may still be required to use a day's paid holiday for bank holidays, including if they're furloughed. Now, if you're in your contract, your bank holidays are given on top of the 5.6 weeks paid holiday. Employees and workers, they should check their contract and talk to the employer, this is what it says in the guidance, about taking this holiday. And also maybe ask whether, if you usually work on a bank holiday, but you're currently on furlough, can you defer that and take it another time at a later date? If employees and workers can't take the bank holiday off because they're actually sick, or the new working time regulations guidance actually say if it's due to coronavirus, so it's something wider than just being sick, they are able to defer it and use it at a later date if it falls within those first 4 weeks of statutory paid holiday. That can be carried over now for a further period of 2 years because of the coronavirus situation. What about previously booked holidays? Now, an employee may well no longer want to take time off because their holiday plans have fallen through and there is limited opportunity to enjoy a holiday, even though you could have a rest. The employer can still insist that they take the time that they've already booked off, although it's clearly best practice to agree that with the employer, explaining why, which is usually the reason that you can't accrue a whole chunk of holiday because the business is going to need people in once this pandemic has plateaued and people can come back to work. If the employee wants to change the time that they are taking off, they will need to get agreement about that from the employer. So there are particular points to note here. There is no particular provision in the guidance preventing taking holiday leave during furlough. I've already mentioned the changes to the working time regulations, which will help employers manage their holiday leave going forward. So where holidays cannot be taken in the current holiday year because of the effects of coronavirus on the worker, the employer, the wider economy or society, that can be deferred for up to 2 years or carried over for up to 2 years. However, if the employer is not on sick leave or statutory family related leave, they can be instructed to take their leave at a particular time. And the notice that's required to take leave will be either in the contract, and if that's silent, the default position, which is that it's twice as much notice to be given as the period of holiday leave which is to be taken. And that notice is given by the employer. Now, coming back to the difficult question of the amount to be paid, this is an area where we're lacking clarity at the moment. With regards to the amount to be paid, an employee taking leave during a period of furlough should be paid the usual pay in full. Now, the revised ACAS guidance says that will probably mean it's the salary regardless of any contractual variation agreed. However, if the employee agrees furlough of 80%, it could be argued that leave should be taken on this reduced, on their usual pay. If somebody is based on, if somebody is therefore not paid their full amount and is only paid the 80%, the problem would be that they would have an unlawful deduction of wages. Of course, this, whilst it's a risk at the moment, it's unlikely to be something that's particularly going to come up straight away. And of course, if there were any claims and you were paying less than the full amount, these could be settled in the future, or when we have clearer guidance as to what the amount might actually be.
And of course, Siobhan, we should point out that the august authority, this is HMRC's Twitter account, has said that holiday pay should be based on furlough pay, which of course places them in conflict with what ACAS says, which it should be usual pay.
That's right, and this is a bit of a problem because there's such an iterative process that we're getting bits here and there, none of which are necessarily authoritative. Even the ACAS guidance isn't binding on a tribunal, it's only guidance that they will refer to, but it's not the law.
So I suspect in terms of claiming money back from the Treasury, that what HMRC has chosen to say on its Twitter account will be jolly useful to have. However, employment tribunals have traditionally taken more notice of ACAS. We're really hoping that this one is going to be sorted out soon, and watch for an announcement from us. We'll let you know as soon as it does. Now, I'm very conscious that we are already running sort of 7 minutes over time, but I do want to try, if I may, just rattle through some of the questions that we've had. So it's been asked, who said that the portal is going to be up and running by April the 20th? Well, that would be Jim Harrer, the Chief Executive of HMRC, and he said it to the Treasury Select Committee this morning. So that is straight from the taxman stroke horse's mouth. We've had a question that says, can somebody come in on furlough, for example, to respond to a fire alarm? Would that break the furlough? Answer, as the guidance is written at the moment, yes, it would. Similarly, we've had a number of questions from people about directors, so who are directors themselves, asking what it is that they can do as directors. Can they keep whilst on furlough? Can they take steps to keep the business going, to develop new work for when the whole business can come out of furlough? Fearing otherwise, of course, they might not have a business at all. Again, the guidance seems to be quite strict. You can perform your statutory director's duties, but no more than that, which I can appreciate is a bit of a blow and is going to make things very difficult. And there's a huge grey area here that people are going to have to take a view on risk. Clearly, the more you do, the less likely it is that HMRC will ultimately pay out. One question which I'd like to answer, because it's actually come up from a client to us in practice, an employee who resigns prior to a disciplinary hearing where they were probably going to fire them, now wants to be re-employed and immediately furloughed. Is it reasonable to say no? To which the answer is yes. The government say you can take employees back, and perhaps there I can pick up the questions we've had from some people. What about people already working out their notice? It would have expired after February the 28th, so they're on payroll on the relevant day. Can we just extend their notice? I think the answer to that is yes, you can. However, for returning to this miscreant individual, do you have to take him back? No. And Siobhan made the point earlier about there are issues around refusing to take people back. You need to be careful about things like protected disclosures and discrimination. But on the face of it, you've got a pretty good defence to any claims if somebody resigned rather than face disciplinary proceedings. They could, of course, wrap up refusal to take them back on as part of compensation for loss for any existing discrimination claims, but you'd have those anyway. The furloughing situation doesn't make any difference. Right, thank you very much, everybody. We probably ought to close now. Apologies if we had any sound issues. We're, of course, only working from the microphones we have with our computer. Those of you who follow me on Twitter will be able to see the somewhat Heath Robinson contraption that I'm using. We will keep you posted. Please sign up for our alerts, and we'll let you know of any changes. If you have any questions, please do get in touch with Siobhan, with Richard, with me, or your usual contact at Gowling. Thank you very much for attending.